there. So this paper is a paper that I think several of you have seen, and I should say at the outset it's benefited from a bunch of comments from people, many of whom are in the audience, so I appreciate that and hope you'll see the changes I've already made in response to your comments, and looking forward to more comments from you to make this paper even better. So the title is Causal Responsibility in Patent Infringement, and I think the principal goal of this paper is to address a lot of problems we see induced in the divided infringement context in cases like Causal and Akamai, and try to figure out what we can learn from common law, criminal law and tort law in particular, and I'll talk about some justifications for using these areas of law, but I think the general justification is avoid patent exceptionalism. We talked a lot about it. Peter earlier today talked about legal universalism. Apply trans-substantive principles to problems in patent law, as opposed to patent-specific rules. You'll learn from judicial experience with analogous problems, assuming they're analogous in other areas of law. And the cases already rely a ton on common law. Akamai, Common, Global Tug, and Grokster, we read them all to make sure, and they both make use of the criminal and tort law concepts. And finally, litigation-driven analysis, they're all scholars, people seize upon certain restatement provisions. But I think our goal should be to understand these areas of law better to ensure we apply concepts correctly and make use of the full range of available tools. So the problem here, right, is what to do when more than one party is involved in the commission of an alleged offense, right? And more specifically, what if the defendant has not itself performed all the acts constituting one or more elements of the offense? So there are derivative and direct theories of liability. I think the first one should be more familiar for those who are non-performers. So derivative requires a principal, so another party who commits the offense, and some connection between the defendant and the principal. And that the Supreme Court decision, in Akamai, Limelight v. Akamai, reinforced this idea they have to have, an infringement, some principal party infringing. I should say that D has to be liable for the same offense, but an actual finding that the principal is liable, a judicial determination is not required. So that actually wasn't clear until 1980, whether you can convict an accomplice without actually convicting a principal, and the Supreme Court put an end to this sort of a medieval logic. If you don't know, haven't actually have a convicted principle, we can't have an accomplice. But there's another way, not a derivative approach to liability that really has been ignored in patent law, I think, and it does not require or depend on the existence of any principle. The sort of theoretical justification, which I'll run through later, is that the chain of causation runs directly for something the defendant did to the act that another party at the state or plaintiff in a civil case is complaining about. And the crucial thing to understand is that it's the acts of another person, not the liability of another person, that are imputed to the defendant, and we'll try to unpack that as we go through this. So just to give you sort of a few more examples of derivative and direct, so classic examples in criminal law, helping a principal, so sort of a weird example, holding a principal's baby while the principal stole some cash, New Mexico case, and then civil and criminal context, you have accountants helping a company defraud its investors. You respond to its superiors, considered to be derivative theory. Actual agency kind of straddles the line, is often treated as direct. So the direct theories for non-performers is one, and the one that's Federal Circuit, I think, appears to be ready to adopt, is concert of action. So multiple assailants against a single victim, it doesn't matter who delivered the final blow, they're all principals, all guilty as principals. And then this area of imputing liability or imputing acts that I'll focus on is this innocent agency or passive conduit theory, where the intermediate, the performer, is like a tool or some kind of a hammer, some passive actor that sort of has no idea what's happening, and that person's act is imputed directly to the defendant, right? And the justification is the translation from this Latin phrase, he who acts through another does the act himself. That's been used to justify actual agency, but also innocent agency. So there are two different forms of agency. And I'll give you one example. So in English law, there's been a lot of unsatisfying results. One example is a bus conductor was waving a driver back to signal that it's safe to back up, right? And in the process, he did that negligently. He wasn't paying attention, and the bus ran somebody down. So the direct actor was a bus driver, but he wasn't negligent. He was just following standard of care. He was following what the conductor was saying. The conductor didn't perform the act, right? It's the bus driver who was doing the driving, so nobody was liable. And that was just extremely unsatisfying to English courts, and they developed, or these kinds of results, and they developed this theory to avoid these results, which seemed absurd. And so let's go through then examples of innocent agency. So, and it is sort of a case of split elements in a way. One party does actus reus, the other one has a mens rea, or some kind of a standard of fault, right? So the easy case is coercion. if I make somebody do something under the gun, it makes it easy to impute the acts of the person whose life, choosing between, break into the bank or I'll kill you type of thing. So you can say the burglar, the person who's holding the gun is the principal, principally liable for burglary. Other examples, which are a little bit, more controversial maybe, but totally accepted now, is where the third party is just clueless. So A, the defendant, I guess I should have used D, asked the third party to deliver a drink to a victim, and A is unknown to the third party, spiked with deadly poison. So again, you can have derivative liability here because T lacks the mens rea, right? But the courts, find a way to deal with this, and then A hands off a fraudulent document to T. Same idea. I'll give an example in this case. So the analytic structure here is D causes T to perform an element of the offense, and which is legally equivalent to doing it yourself, right? And of course you have to prove the mens rea, whatever the mens rea is, right? So case law examples, actually the best statement of the doctrine is in a dissent in this interesting case involving a federal climber making false entries. So a bank teller was withholding deposit tickets from bookkeepers, and that, according to the theory, the prosecution caused the bookkeepers to make false entries, even though he wasn't actually writing anything down, right? The Fifth Circuit actually exonerated this guy and said, well, he didn't actually make the false entries. And the dissenting judge here said, well, one can do a criminal deed with your own hands, or you have indirect mechanical means, or a spring gun, or an innocent human being. You can't say, oh, the spring gun did it, I didn't do it, right? And same idea would hold this Giles guy liable. The Supreme Court agreed with the dissent, reversed 9-0, I think this was an error of cert too, and said, false entries were the intended and necessary result, we'll talk about intent a little bit later, of the respondent's deliberate action in withholding deposit tickets. Notice that the statute did not have the cause false entries to be made language. In 1937, this cause to be made language has become applicable to all the federal criminal statutes through 18 U.S.C. 2, which was amended to include it in 1951, I think. And it's a very interesting result in view of the rule of lenity, right? We usually try to interpret criminal statutes to, if they don't make it clear that the conduct is prohibited, make you guilty. But nevertheless, it doesn't stop the court here. And then the cases do make it clear that this theory is distinct from, accomplice, co-conspirator, like there's no meeting of the minds here. This is truly an innocent agent, or aiding and abetting theories. And, this is quoting from a treatise, sole and unaided will, person comes to criminal transaction, whatever physical agencies he employs, including another human being, and whether he's present or absent when the thing is done. So that's the basic doctrine here in this area of law. So some theoretical perspectives from criminal law scholars and actually some civil law scholars as well, and philosophers. So there's a point at which the instigator becomes the principal offender. So there's a sort of a sliding scale where, takes you from secondary to primary liability. You could think of it that way. Causing actus reus of the offense, even though the immediate actor is another person. Similar idea here. The stronger the accessory's causal role, the weaker the perpetrators. And again, the focus here in causation. Who is causally responsible? And you can call this person principal. A theoretical tool here is causation is scalar. There are big causes and little causes. And Michael Moore sort of propounded this theory. He says, well, substantially aiding another to cause some harm is to cause the harm yourself. And notice, of course, you remember from tort law, there's sort of intervening causation, the intervening human acts that might cut off the chain of causation, but not neither. And finally, one more point to clean up is the word innocent really is misleading. You could have a principal who is liable for something, right? And this classic example comes from Sandy Kadish's paper on the Othello-Iago hypothetical. So Othello might be liable for voluntary manslaughter only because the crime was committed in the heat of passion, but Iago actually could be liable for murder. And there are actual examples of cases like this. So you don't need to have a purely innocent principal or direct performer, however you want to. So you might ask, and people have been asking me, why criminal law, right? Why is this really the right analogy? And I think a few reasons for this. So patent law, and unlike tort law, I think clings and struggles with the direct and indirect distinction. And there's a statute, federal statute at some point in both cases. In tort law, this distinction is quite underdeveloped. I talked to Bob Rabin, who is a noted tort scholar at Stanford and has co-authored a case book, and I used the word secondary, indirect, and so on. And he's like, well, we don't really use these concepts in tort law. You may join tortfeasor principles. But I think it's safe to say, and Mark Bartholomew has written on this, that this aiding or a secondary liability concept outside of like aiding and abetting civil fraud or something like that is really quite underdeveloped in different principles they use. So criminal law, in fact, has dealt with the accessory liability and accomplice principle doctrines much more. In patent law, there's a better fit there. we already rely on criminal law and patent law a lot. That might be a mistake, and people have written on this too, whether willful blindness, a culpable intent are the right concepts to be using in criminal law. Note that actually culpable intent is not required in tort law, even for intentional torts like battery. You only need is unconsented, unwanted touching, and that's it. You don't have to actually have an intent to cause harm, which is interesting. And you can argue that, well, causation concepts are transsubstantive, even maybe translegal. What does it mean to cause an act of another person is a philosophical question, right? It doesn't have to do with the area of law you're in. And if anything, at least in the area of proximate causation, the scope of causation in criminal law tends to be narrower than in tort, and to the extent that the criminal law allows for liability a fortiori, civil law should probably allow for liability, right? But people have been pushing me to still, and I think that's the right thing to do. What about tort law? Is there innocent agency? Are there good examples? So one example I can give you right off the bat is trespass, which is rightly or wrongly has been analogized to patent law. So, and notice in the actual section there is statements that causes a thing or a third person to do so. So a person is equated to a thing in a way in the sort of statement section. So just like you can say, oh, I can't get out of trespass because my car did it, because I drove the car into someone's land. You can't say, oh, I asked someone else to do it. And it's clear that you don't have to have a command or some kind of a obligation. So the common J says commanded or requested a third person to enter land. Notice that the section doesn't call this liability secondary or anything like that. But you do have to have an intentionally cause another to do an act under the same liability. And we'll unpack this later too. But intentionally here manifestly does not require awareness of the legal right. So the awareness that the land is someone else's, right? To intentionally cause, some people would argue, is actually superfluous because inherent in the idea of causing an act of another person is the intent that this act be carried out. But sometimes courts will split and say just awareness of another person's act or knowledge is enough, and that's not right. But we'll again talk to that a little bit more. By the way, 18 U.S.C. 2 has this willfully cause language. And again, learned in hand opinion said, well, this willfully is just unnecessary. To cause someone's act is because before the statute was amended, somebody was prosecuted, under the previous first edition of the word willfully. So anyway, so there's that. Talk about this a little bit more. But I think an even better example for what I'm trying to say is strict liability for manufacturing defects and strict products liability in general. So consider a famous case that I learned in my second week of law school. So Chrysler sells the car with defective steering. There's no tort until the driver collides with a third party, right? It's sort of a divided tort problem, right? So, but Chrysler is still strictly liable. Notice if you define the tort as driving a car or colliding with somebody, with a car having defective steering, that's sort of an inducement case, right? Because Chrysler didn't collide with anybody, right? They just made a car that was defective. Well, you can make it. They seem like a divided case where Chrysler introduced a defect, but the driver collided with somebody. But the courts don't even think about analyzing this as a secondary liability issue, right? And there's some rationales for this. The product in the hands of the consumer is a mysterious article. It's a sort of a passive innocent instrumentality type reasoning. More importantly, there's no privity requirement. As we all know, courts impose a direct duty from the manufacturer to the injured party, even though a retailer or someone else may be interposed. And no less authority than Prosser says, well, the middleman is no more than the conduit, a mere mechanical device through whom the thing is sold to the ultimate user. So that sounds very much like innocent agency type language. And finally, sort of, why do we hold manufacturers liable here under these facts? Having invited and solicited the use, you should not be permitted to escape, avoid responsibility when the expected or intended use leads to injury and loss by claiming that you made no contact directly with the user, right? So that's important. So I think, I'm more than willing to take criticism of course, maybe this is a wrong analogy to use, but it seems like there are some analogies between this and what you see in patent law. So let's sum this up. So when is the imputation of act from another party to a non-performing party appropriate? You have actual agency. You have co-perpetrators, and again, in outcome I see that being accepted, but then this innocent agency passive conduit theory that again has been ignored. And what do all these have in common? Well, they're not really assistance or encouragement cases. You really have a non-performing party who's in control, and you can say, well, maybe the Federal Circuit just misunderstands its own direction and control test, I don't know. But the point is that aiding and abetting theories, in contrast, tend to result in liability for mere assistance, and some people don't like this. If you're just an assister as opposed to a person in control, maybe your liability should be less. Or maybe if you're holding somebody's baby, you shouldn't be liable for robbery, larceny, something like that, you should be liable for something less. As we have it right now, you treat assisters, aiders and abettors equally, but my point is that this is a different route to liability when you impute acts of others. So just to sort of sum up the factors, when should innocent agency apply? You have active participation in a non-performing party. You provide a tool and instrumentality that put together a design like a poison drink or fraudulent document or a car that encourages the performers to carry out acts that end up becoming an element of the offense. You have to have specific intent, and that maybe explains why 271B doesn't have a mens rea, right? So at least not stated in the statute, right? There's no separate mens rea. It's inherent in the idea of causing an act of another, right? You don't need to say willfully cause or intentionally cause. That's what it means to cause an act of another person, is to have intent that this act be carried out. And then on the other side, you have to have passivity of the performer. So like, either you're really acting under duress, or you're just unaware of some crucial pieces of information, or you just consume in a stream of commerce. In criminal cases, you have no idea that the performer is up to no good, that the drink is poison or something like that. In tort law, you have no idea how the device works, and the complaint of act happens when the device is used as unintended, so it's mysterious. So now, sort of moving this to patent law finally, and this, I've gotten a lot of feedback and criticism on this test, and I've been trying to modify it, but in some ways, you might see imputation of acts of others in patent law. When you have a device that lacks a substantial infringing use, I think that's important, and advertises or otherwise encourages performance in one or more steps. So it's sort of combining B and C in some ways, so that it's important that the user has to perform the claimed steps to get the value out of the product, whether it's in divided or inducement context. And the user has to be passive, right? Not a manufacturer using patented technology or component or involved in distributing technology. So a regular computer user or a coffee shop using Wi-Fi and so on, something like that. And tort law makes these distinctions all the time, of course, so I don't know why patent law cannot. And so you'll see if you think the rest of the story that the causal imputation deals with the outcome my problem in cases like this, and also changes some B cases into A. And again, you have to have advertising and encouragement as part of sort of proving intent. So a couple of things, would that make B and C redundant? Well, you still apply to non-infringing uses in B, and then C, classic case like American cotton tie. It's really that section seems to have been intended to apply to manufacturers to supply components to be used by other manufacturers, not necessarily customers. And again, I'll add to this that 271B uses the term infringer rather than contributory infringer, and the word induces already applies to a broad range of conduct, so that maybe this section is capacious enough to induce causation, and the statute itself sort of blurs the distinction between A and B by sort of pointing back to A, just like the federal criminal statute does in a way. And the approach is similar to Mark Lumley's sliding scale mens rea approach, really. So you'd have to have some kind of high level of mens rea when you have non-infringing uses, but when you have passive customers and no other use for the product, you have a lower level. And I'm glad to see Keith in the audience, and he sort of brought this approach up. Again, in a recent paper, and sorry about the spelling of extended there, and that sort of this presentation really sort of theorizes why you might want to see that based in tort and criminal law principles. So, quick note on other areas of IP. This is something that Patrick Gould and Sean Balgner pointed out to me. Aereo doesn't seem consistent with this in some ways. Of course, copyright law is a different statute, but here you press play and provider is directly liable. So the blurred line does exist in other areas of law, and why C-enter matters. I already sort of discussed this. In patent law, the defendants are really intermediaries, like in copyright law, and they make the very subject matter. And finally, sort of again, policing infringement seems weird when you make a device that lacks substantial infringing use. And finally, notice problems. Talked about that with a bunch of folks, and the idea is that's a general problem with strict liability, right? This is a form of direct infringement I'm proposing. And the linchpin of strict liability is causation, not fault, right? So it's just about showing causation, and also just kind of economic angle here. As between clueless users and manufacturers in the scenarios I've described, who is in a better position to search for patents, right? I think that's pretty clear. Anyway, and then in terms of claim drafting, that's an argument also have whether you have a large amount of uninfringible patents. But anyway, so that's the basic paper. Sorry it took so long, and looking forward to your comments. Ted.
So I really like this project. I think, as I've read before as well, that a lot of our foundations for infringement and indirect infringement have not been properly examined historically or with respect to tort law or the overall aims of patent law. So what you just discussed at the end, I'm most interested in, that's scienter. And you talked about it a little before that, but as I've written, historically and in tort law, for all these types of secondary or indirect liability, as we call them, in patent law, there's no requirement that you know what you're doing is some sort of legal violation. And now we have that. So what would you suggest along those lines as a policy matter? And to the extent it's different from tort law, or maybe should be different, how does that tie back into your overall project of using tort law to basically categorize or even inform the different types of infringement we have under patent law or other types of IP law?
So I agree with a lot of the analysis in your paper about the historical origins of this. I think I'm sort of looking at this problem a little bit as an advocate, and maybe that's good or maybe it's bad, but I think I'm proceeding with the assumption we're stuck with sort of Causal global tech line of cases about what else can we do to sort of still bring back tort principles while not violating that precedent. I think the innocent instrumentality doctrine, which has been in the background of common law when the 52 Act was passed, can still, in the really egregious cases, right, provide a way of getting around the knowledge of the patent requirement, which you've suggested is wrong, and I think I tend to agree with that. But also solve the Akamai problem, which is a new problem, but really a new problem that has an old solution, right? So I think the idea is, I think it's too late to get the Supreme Court to overrule its precedent, but in a limited number of cases, we have these passive consumers and active manufacturers. You might still use these tort principles and not violate, the precedent that we now have in the Supreme Court. That answer, Mark?
So, two thoughts. One is, the Akamai test, it seems to me to encompass a large amount of what you're talking about in the direction or control idea, right? So it's not to say that patent law doesn't have this doctrine. It's that patent law actually did import this doctrine. And then I guess beyond that, if we're going to talk about sort of this innocent conduit and holding the original person liable, we run into the problem of what it is we consider to be the wrong, right? And that's pretty clear most of the time in criminal law, right? It's not the act of placing the thing in the mailbox, it is the fraud with the intent that it go into the mailbox that we consider to be the wrong. It's not at all clear to me that it is obvious in patent law that a patent claim that has 5 elements, performing one of those elements in isolation is a wrong. Right? Manufacturing a computer is an element which is ultimately combined with other people, but it's not clear to me that we want, absent some knowledge of the wrongfulness of the ultimate act, to hold the manufacturer of a computer liable because that computer turns out later to be used in a way that violates the patent. And so I don't know if there is a closer analogy in criminal or tort law to things where the act we're holding someone liable for is itself not wrongful, has a substantial non-infringing use, but those would be the close analogies you'd want to look for.
So you didn't buy my strict products liability analogy, or?
Well, I think that is a departure from normal criminal and tort law principles that we did as a policy matter because we felt like those people were in fact doing something which imposed costs and they ought to bear those costs.
I see.
That's an easy case, I think, if I'm manufacturing the whole car, right? If you want to hold liable the manufacturer of the bolt that went into the steering wheel because they helped to produce the thing, which turned out to be defective, I think you'd have a much harder case.
Yeah, I see what you're saying. No, to answer your first question, I think the direction and control test is, I think, broad enough to encompass these theories. It's just that the Federal Circuit hasn't done it. Maybe that was the point of Judge Moore's dissent on Akamai, right? Under media auction, BMC, you actually could hold these parties liable based on some other idea of control, right? So that's well taken. It's just, it's sort of devolved into agency and contractual relationship and joint enterprise. The second point, I guess, if a product has an intended use and that intended use involves a specific step that would be covered by a patent claim, I guess that's sort of where
Sorry, did you realize the time had run?
Oh, yeah.
Sorry.
So I wanted to answer my question. Sorry about that. I totally blew past it. My bad. Thank you for your questions and thanks for your time.